It's wonderful to be here, although I have to admit that Bruce has now said everything that I was going to say. Thank you very much. That concludes my presentation. I actually was almost late because I was writing an op-ed. And so I thought it would be a good place to begin. I was writing an op-ed. Really, I was literally drying my hair as I was sending this off to the Globe. I was writing an op-ed about voir dire, about the questioning of jurors, because I had been watching what was going on in the Tsarnaev trial, watching what was going on in the Hernandez case, and watching what was going on in Colorado, with the judges selecting a jury for the Colorado shooting case. And this is an area where, what Bruce just said a moment ago about the over-promising of science, I think that's a wonderful concept. I believe that we over-promise in law. And what I very much wanted to write about was how we over-promise justice to some degree in the way that we select our jurors. And I got into this because I was a baby lawyer and didn't know what I was doing and wound up in a murder case which was way over my head. And I went to social scientists, literally, psychologists and people who had studied the jury for advice. I didn't go to other lawyers. I went to outside the profession to try to figure out how to be a lawyer. And they said, we have careful interviewing techniques when we interview jurors. When we interview people in decision research. We are careful about open-ended questions. You want to make sure that the questions are simple. You want to make sure that the questioner is on the same social platform as the person questioned. There are all sorts of things. We think about how we ask questions in order to get honest answers. And how do we get real answers? And then I think about the courtroom. And then I think about the Massachusetts courtroom. And I was there. I was a judge. I was a lawyer in that courtroom. And I think about what I have described, and unfortunately, I'm now being criticized for this, I described as the dopey judge question. And the dopey judge question was the judge in the platform, on the bench with robes, generally a male, stentorian voice, turning to the juror and saying, "Mrs. Smith, I understand that you've read an enormous amount about this case. You know all about it. You just were reading about it moments before you came into the courtroom, but surely you can be fair." And the juror looks at the judge and says, "Oh, yes, Judge, I can be fair." And we call that meaningful questioning. So I wanted to write a voir dire about the difference between questioning in science and decision research. Not a voir dire, an op-ed. The difference between questioning in science and questioning in social science, rather, and questioning in law. There are lots of things about the courtroom that actually make jurors, enable jurors to really search their souls in a way that the ordinary decision research might not. But there's also a lot that's just theater. And I wanted to identify that. And I wanted to do it now while these discussions were going on. So that now points to what Bruce was saying. It's not just what you write. I had 1,000 words on Saturday, and the op-ed is 700. And between Saturday and Monday, I had to figure out how to get this down to 700. And I'd been a judge, right, where nobody ever stopped me from talking. So this is a serious challenge. What's great about writing opinions is that, I could just go on and on and on. I also loved writing opinions because whereas all of the scientists in the room had to beg someone to publish, I could publish whatever I wanted. I pressed a button, it was published. But I had to go from 1,000 words to 700. And I had to get it out by Monday. I had to get it out because if I didn't get it out in the midst of this conversation, it was now an abstraction. So it's not just what you say, it's when you say it. I have to admit that when I left the bench, that was very troubling to me. First, the notion that you had to get it out there very quickly. This is a very different world. This is a world of blogs. This is a world of people commenting on what you write. This is a world where there are so many outlets, I didn't even know where to go. And there's no branding. I write for the Globe because I like the Globe brand. I write for the New York Times on occasion. But the idea is, where do you write where it's legitimate, where someone understands that there's some pedigree to the writing? So it's not just when, but it's where do you publish. But we have to. That's the sort of the why point. We have to. It's not just a question of global warming and issues like that. My particular area, which I'm particularly interested in, is criminal justice. And I watch a criminal justice debate that's been going on for 20 years, which is absurd. My first entry into the op-edisphere, if there is such a thing, was when Massachusetts was going to be the first state when other states were cutting back on their juror population, all of a sudden Massachusetts was going to increase their juror population with a 3 strikes you're out bill. And it was based on a very celebrated murder, the Gossel case, which was on the Cape. It was a young woman who was killed by a man who had multiple small crimes, none of which would have ever flagged what he did. But that crime became the basis for a bill, and the bill was 3 strikes, you're out, 3 felonies, and you're now in for a longer period of time. The irony was that the Gossel case, which had led to this discussion, would not have been prevented by that bill. And indeed, that bill swept much more broadly than anyone could have envisioned. Felony is a term of art that covers many, many things. So I wrote an op-ed. I said, I know what mandatory sentencing is. I understand what it's like. I've sentenced 534 people over 17 years. I know exactly who wound up with the mandatory minimums and who did not. So I wanted to engage in this conversation, because if we don't engage in this conversation, we wind up with 3 strikes laws. We wind up not just with defunding, but we wind up with a criminal justice policy that bears no relationship to reality. So when we have to respond is critical. What the context in which we respond, the places that we respond, and then why is essential. Otherwise, we reap what we have sowed in all of these areas. Then the next question is who? The irony is that judges, for example, who might have the most to say about much of this are silent. I like to say that I left the bench for the purpose of speaking. People who know me said, and exactly what were you doing on the bench all those times? I wasn't, really silent on the bench, but I generally got in trouble for whatever I said. If you said something, you could be sure that in the next case, somebody would try to twist this to disqualify you. There are ethical rules about what a judge may say. It's very, very troubling, and it's very difficult then that the people who know the most, or at least have, on the ground observations about things, are the ones who are the least able to speak. And that's part of the reason why I wanted to leave the bench, because I wanted very much to speak in the way that I'm trying to do. Lawyers don't know how to talk. Some do. If you're a jury trial lawyer, you might. I've been teaching now for 3 years at Harvard, and from that experience and the experience with my law clerks, I can tell you that lawyers, like scientists, have lost the ability to speak. I like to say that it's almost as if they were functionally illiterate before they went to law school, and now you've somehow superimposed legal language on top of this, so that they literally have no idea. Lawyers talk, the law students are taught to speak law. They speak to judges who also speak law, and the judges speak to the Court of Appeals. And it's a closed circle, and no one speaks to the public. Let me give you one, my favorite word today is dopey example. Patent cases. The bread and butter of scientists, patent cases. We would get patent cases, and there was a very celebrated judge in my court who's now gone, very smart judge, who had a patent case that he did not understand for a minute. He didn't understand a word of it. His law clerk drafted the opinion. Another scandal, I might add, but we'll leave that aside. The law clerk drafted the opinion, and the judge didn't understand what the draft said. The judge said, never mind. He said, I'll sign this, let the Court of Appeals figure this out. The case goes up on appeal. The arguments are presented. An opinion comes down within a week for substantially the reasons described in the district court. It was essentially the game of telephone. Remember that as a child, which is someone says X, X is then muttered in the ear of everyone. It comes out as Y. No one had any idea what the context was, no one had any idea what the framework was, and no one tried to unpack it. So I try to teach lawyers law students how to unpack it, how to speak to each other, how to speak to juries, how to speak to the public. As a judge, the first 10 pages of any decision I wrote was a press release. It was a press release. It was written in English. I knew the reporters were not going to read after page 10. This is very interesting, this comment about letters to the, I knew, and in some cases it would have to be the first 3 pages, because God knows what they were going to do after that. But the first, and it was almost as if I was having a discussion with myself. The opening would be, I know what you're going to do with this decision, I know what you're going to say, you the public, and let me tell you what the answer is. But judges are not taught to speak to the public, they're really taught to speak to each other, and worse yet, to speak to the Court of Appeals. So the translation process is really essential. I was just at a cocktail party a couple of weeks ago, and I ran into the founder of is it the Broad Institute? Broad Institute, Dr. Lander, who describes teaching Barry Scheck DNA. As really, that essentially, Barry Scheck had just learned, the famous lawyer had some idea of what the significance of DNA, and he literally had a case involving DNA, and Dr. Lander sat down with him for hours translating the implications of DNA into the courtroom. And that, of course, the rest is history. That translation was essential. So I want to conclude. I'm working with CLBB on the implications of neuroscience and the law, because neuroscience offers the promise and the fear. Both promise and fear, implications that are tremendously interesting and important, but also troubling and prejudicial. And if we don't figure out how to talk to one another and translate these issues in advance, these new scientific discoveries will bounce in ways that will be frightening to all of us. So CLBB is a platform for this kind of translation, but we have to learn how to do it. We have to learn how to take 1,000 pages and turn it into 1,000 words and turn it into 700 words. And the Globe is going to email me during the course of this program to tell me what they're going to slash and burn further, and I will walk out and have a conniption fit. Thank you.